Well, good morning, everyone. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, April 28th, 2021. The time is 9:30 a.m., and I'll begin with a roll call. Good morning, Commissioner Lindley.
Good morning.
And good morning, Commissioner Ginecka.
Good morning.
Our commissioners are all present. How about our General Counsel? Good morning, Ms. Smith.
Good morning.
And our Public Interest Counsel, Mr. McWhirter, are you there?
Good morning. Yes, I'm here.
Good morning. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who's here only to listen that they can also watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration is now closed, but if you'd like to address the commission on a particular item, we'll try to accommodate that. Please email agenda@tcq.texas.gov with your name, affiliation, and the item you'd like to comment on. For those making presentations, please wait to begin your presentation until I or our general counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you speak. And with that, I'd like to thank everyone for being present. And Ms. Smith, I'll ask you to please call the first item.
Chairman, I understand on the first item that our respondent may be having difficulty signing into the webinar. Can we take up item number 2 first to allow him some time to get situated?
Appreciate the suggestion. Let's do that. Thank you.
Item number 2 is the application by Denton County Municipal Utility District number 10 for new TPDES permit number WQ00158030001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. And for the benefit of those who are not familiar with our process, we have a two-part analysis for considering requests for contested cases. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester meets the requirements, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Governmental entities must have statutory authority or another interest in issues relevant to the application in order to have standing. Colleagues, I count 9 requesters on this item, 6 of which, in my view, have met the procedural and substantive requirements to be entitled to a contested case. One that was a little bit on the bubble, Mr. Boyer's request is somewhat ambiguous. He cites several concerns that are outside our jurisdiction on this authorization, but I think his request can be read as raising relevant and material issues about environmental impacts generally as they pertain to him. So I would grant his request as one of the 6. I'll also note, I'm including the City of Justin in those 6. The city has raised regionalization as an issue, and since it operates a treatment facility, I think it's appropriate to grant the city's request as well. The 3 remaining requesters, Janet Malloy and Gerald and Crystal Massey, simply failed to file timely comment. So under 30 TAC section 50.115C, I believe we're compelled to deny their requests. So let me pause there and see how y'all came out on the requesters. Commissioner Lindley?
I came out with 6 as well, and just to state their names, I guess. I agreed on Robert Boyer, Karen Haggerty, Kathy James, the Cope Trust, Cope Circle Rentals Incorporated, and the City of Justin were my 6.
Yeah. Commissioner Ginecka?
Likewise in agreement. I agree with you, Chairman, in finding Mr. Boyer to be an affected party and to find that Ms. Malloy and Mr. and Mrs. Massey were not affected by virtue of not meeting the statutory test by getting their their requests in during the appropriate period of time.
All right. Appreciate that, colleagues. Turning to the issues, the test is we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. And to put that another way, the issues must be within the Commission's jurisdiction on this particular type of application. So, for example, on this application, the Commission can't consider issues of flooding or property values. Those issues are simply beyond our jurisdiction. With that said, I would refer 8 issues as follows. Whether the draft permit is protective of water quality and the uses of the receiving waters, whether it complies with applicable nuisance odor requirements, whether the Commission should deny or alter the permit based on need or regionalization, as those ideas are articulated in Chapter 26 of the Water Code, whether public notice was adequate, whether the draft permit is protective of groundwater and well water in nearby wells, whether the draft permit is protective of the health of the requesters and others who are residing nearby, whether it is protective of aquatic vegetation, livestock, and wildlife, and finally, whether it meets the applicable siting requirements, including buffer zone requirements. So those are the issues as I see them. Commissioner Lindley, how does that sound?
I'm in agreement.
Commissioner Janeka?
Likewise, I captured all my issues.
Okay, a few remaining issues. As to the city's request for reconsideration, that was made without alleging new facts, so I think we should deny that. And I would also recommend a concurrent ADR referral here, as well as to allow the full 180 days for the hearing. And if that sounds all right to you all, I'll entertain a motion.
That sounds good to me, and I'll attempt a motion. I would move that we grant the hearing request of Robert Boyer, Karen Haggerty, Kathy James, the Cope Trust, and Cope Circle Rentals Incorporated, and the City of Justin, that we deny all other hearing requests and requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit is protective of water quality and the uses in the receiving waters under the applicable surface water quality standards in 30 Texas Administrative Code, Chapter 307. Issue 2, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code, Chapter 309.13. Issue 3, whether the Commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code, Chapter 26.0282, and the general policy to promote regional or area-wide systems under the Texas Water Code, Chapter 26.081. Issue 4, whether the applicant substantially complied with all applicable public notice requirements. Issue 5, whether the draft permit is protective of groundwater and nearby water well area. Issue 6, whether the draft permit is protective of the health of the requesters, their families, and other individuals who reside in the immediate vicinity of the proposed facility and discharge route. Issue 7, whether the draft permit is protective of aquatic vegetation, livestock, and wildlife in the immediate vicinity of the proposed facility and discharge route. And Issue 8, whether the draft permit meets applicable siting and buffer zone requirements, including those outlined in 30 Texas Administrative Code, Chapter 309.13. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and that we set the hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, I'll ask you to please call the next item, and I'll leave it up to you whether that's item 1 or item 3.
I understand the respondent's been able to access the webinar now, so we'll go to 1. Item number 1 is the ALJ's proposal for decision and order regarding an enforcement action against Day Night Food Mart LLC. Presentations will begin with the executive director, followed by the respondent, and then the Office of Public Interest Counsel. On April 9th, 2021, the Office of Chief Clerk notified the parties that they will each have 5 minutes of oral argument in accordance with the Commission's standard practice. The ED may save some of his time for rebuttal as the ED bears the burden of proof.
Thank you, Ms. Smith. And I understand, is Mr. Rutledge on for the Executive Director?
That's correct.
Good morning, Mr. Rutledge. Please go ahead when you're ready. The floor is yours.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Ryan Rutledge, and I am an attorney with the Litigation Division representing the Executive Director in this matter. I believe with me today is Haley Johnson of the Enforcement Division, as well as Ashley Pritchard of the TCEQ San Antonio Regional Office. The ED concurs with the Administrative Law Judge's proposal for decision and recommends adoption of the order with the inclusion of the ED's exceptions. For your consideration, the ED would also like to point out that at the evidentiary hearing, the respondent did not dispute the violations cited in this case or that they owned and operated the facility at the time of the investigations. In addition, respondent did not contest that the penalty was calculated in accordance with the applicable penalty policy. We are here to answer any questions you may have and would like to reserve the remainder of my time for rebuttal if necessary.
Thank you, Mr. Rutledge. I don't have any questions at this time. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thank you.
Thank you. And I understand Mr. Wilson is here representing the respondent. Mr. Wilson, are you there?
Yes, I'm here.
Well, you're coming in loud and clear, sir, and good morning to you. And the floor is yours. I'll just ask you to identify yourself for the record, and then go ahead, please.
Yes, sir. My name is Trey Wilson. I'm an attorney in San Antonio, and I've just been recently engaged by the respondent. Let me start by thanking you for taking the matter out of order to indulge me. I was having some technical problems here. I don't have anything earth-shaking to say to you, and I won't use much of your time. I don't disagree with any of the arguments that was made by the ED's counsel. There has been a concern raised by Mr. Ron Ray, who's the managing member of Day Night Food Mart LLC, that he has some reason to believe that the order will apply to him in his individual capacity. Under my review of all of the documents, including the exception, the AFJ's proposed order, it doesn't appear that Mr. Ray is individually a respondent, and I don't see that he was involved in the process or even received notice or citation. And I just want to ensure that as an order is adopted, that order does not include any findings or penalties against Mr. Ray in his individual capacity. That's really all I have.
Well, thank you, Mr. Wilson. I appreciate that. You know, I think the proposal for decision and proposed order, speak for themselves, and we just need to interpret them based on the black letter of those documents. So, I'll leave that to the attorneys and the arguments that they may want to make in the future. But if you're not seeing him in his individual capacity there, that certainly means something. But I thank you for your presentation, Mr. Wilson. Colleagues, do you have any questions or comments based on Mr. Wilson's presentation?
I do not. Thank you.
Not at this time, thanks.
Thank you, colleagues. We'll hear next from Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC agrees with the Honorable Administrative Law Judge and the Executive Director that respondent committed the violations as alleged in the Executive Director's preliminary report and petition. Further, OPIC agrees with the Judge and the Executive Director that the recommended penalty is reasonable and was calculated in accordance with the applicable statutes, agency rules, past agency practice, and the TCEQ penalty policy. Consequently, OPIC respectfully recommends that the Commission adopt the ALJ's proposal for decision and sustain and incorporate the minor changes as contained in the Executive Director's exceptions to the proposal for decision. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Likewise, thanks for the presentation.
Thank you.
Thank you, Mr. Wayne. Mr. Rutledge, do you have anything to offer in rebuttal?
I do not. Thank you.
Thank you. Colleagues, I think as a legal matter, this item is pretty cut and dried. The executive director presented witness testimony and other evidence establishing the violations. The ALJ determined that the executive director met its burden. The respondent offered no rebuttal evidence. Therefore, we have no basis to change the proposal for decision, except for the non-substantive exceptions agreed to in the ALJ's March 11 letter. So that's my view. What do you think, Commissioner Lindley?
I'm in agreement.
Commissioner Ginecca?
Likewise, I'm also in agreement. Thank you.
I'll entertain a motion.
Allow me to move that we adopt the administrative law judge's proposed order with the modifications recommended by the executive director's exceptions and agreed to by the administrative law judge's reply dated March 11, 2021.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Ginecca?
Also vote aye.
And I also vote aye. The motion carries. Ms. Smith, I'll please ask you to call item number 3.
Item number 3 is the application by Talicate Services Incorporated for new TPDES permit number WQ0015843001. The parties have been notified that the commission will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. Colleagues, we again have a two-part analysis for considering requests for contested cases. Part 1 is about who gets a hearing, and Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. On this item, we have 3 requests. In my reading of the materials, Major Bentley has met the procedural and substantive requirements for a contested case in that he established the proximity of his property to the proposed facility with respect to the issue of nuisance odors. So I would grant his request. Mr. Rogers raised numerous issues, but he did that were outside the comment period, that were not timely, so we can't use those to establish party status. The one timely issue that Mr. Rogers raised regarding the discharge route is not, in my view, sufficient for party status, since the discharge route converges with Waterhole Creek more than a mile downstream of his property. So in that respect, I don't think he has a personal justiciable issue. So I would deny his request. And Mr. Butler raises no issues at all, so I would deny his request as well. And as for the referable issues, we only have the nuisance odor issue that Mr. Bentley preserved. That's my reading anyway. Commissioner Lindley, what do you think?
I'm in agreement, and I would say this one might be a good candidate for 150 days as far as a referral to SOA, just because it's one person and one issue. But I'm in agreement with the one person and the one issue.
I certainly think that's reasonable. Commissioner Ginecca, what do you think?
I don't disagree on any of the points raised. I think I'm in full agreement with you, Chairman, in your analysis on affected persons and then the issues, the single issue. And I'm reluctant to start pressing the gas immediately in every opportunity we have, but this is definitely a clear, easy option to do so, Commissioner Lindley. I agree with you on that one.
Yeah, we have one party and one issue. And, I think it makes sense to include an ADR referral as well. We may be able to sort this out without having to go all the way through hearing. But in any event, I think we have all the parts assembled for a motion if somebody wants to offer a motion.
I will move that we grant the hearing request of Richard Ray Bentley, that we deny the remaining hearing requests, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA preliminary hearing scheduling efforts, that we refer the matter to SOA for a contested case hearing on the following issue: whether the draft permit contains sufficient provisions to prevent nuisance odors, and specify that the maximum duration of the hearing is 150 days from the preliminary hearing to issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by Falcon Development LLC for renewal of TPDES permit number WQ0013090000. The parties have been notified that the commissioners will not take oral argument but may ask questions. I don't believe we have anyone signed in on this matter.
Thank you, Ms. Smith. Colleagues, this renewal application does have a somewhat convoluted history and a long history dating back several years. Nevertheless, I think it's pretty clearly a no increase renewal, and under Texas Health and Safety Code, Section 382.056G, we're prohibited from granting a hearing unless there are certain compliance history concerns, which I don't see in this case. So I agree with the executive director and OPIC that we should deny these requests. Commissioner Lindley, what do you think? You agree? Okay.
Yeah.
Well stated, Chairman.
All right. I think we're ready for a motion.
I would move that we find that no right to a hearing exists on the application, that we deny all hearing requests, that we grant the renewal of TPDES permit number WQ0013090000 to Falcon Development LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is the application by Black Mountain Sand Eagle Ford LLC for new air quality permit number 159610. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you, Ms. Smith. On this item, we have 7 hearing requesters, and colleagues, I agree with the executive director and OPIC that Patrick and Lisa Rourke, Gerald and Donna Mertz, Patsy Tatum, and Barrier Equipment have all met the procedural and substantive requirements for a contested case, so I would grant their requests. Both the executive director and OPIC also concluded that the last requester, the remaining requester, Frank Dunn, was situated too far from the proposed facility to establish a personal justiciable issue based on the location of his house. But I believe Mr. Dunn rehabilitated his request in his reply, that pointing out that his employees and guests routinely use portions of his property that are much closer to the proposed plant. So I would grant his request as well. So in effect, I would grant all of the requests. And let me pause there and see how you came out, Commissioner Lindley.
I'm in agreement.
Commissioner Janeka.
Likewise, I've found the same on the basis of Mr. Grant's reply.
Thank you. As for the issues, I'd refer the following: whether the proposed plant would be protective of the health of the requesters, their families, and their full-time residents, whether the proposed plant will be protective of the requester's physical property, whether the proposed plant will negatively affect air quality, whether it will be protective of general welfare, including vegetation, livestock, and the environment, whether the applicant has demonstrated that it will use the best available control technology, whether the proposed permit will protect against nuisance conditions, whether emissions from the proposed plant will comply with the National Ambient Air Quality Standards, and whether the air modeling and analysis account for cumulative impacts consistent with the applicable authorities. So let me, and I apologize, I realize I read through those rather quickly. I'm not sure if you were able to tick them all off. Commissioner Lindley, how'd we do? You want me to read through those again?
No, I think I was able to follow you, and I would be in agreement with everything you stated.
Thank you. Commissioner Janeka?
I likewise was a little muddled on the count. I think I may have double counted 2 that I thought you read separately as a single issue, but I think I'm also in agreement, and I'll listen closely in the motion and chime in if that's not the case.
Okay. And on this one, I think it's appropriate to allow the full 180 days. And given the somewhat limited number of parties, and that they're represented by the requesters are represented by a single counsel, I think an ADR referral would be appropriate on this as well.
I'm in agreement.
Likewise.
I think we're ready for a motion.
I can make a motion and make sure we're all on the same page. So I would move that we grant the hearing request filed by Patrick and Lisa Rourke. And apologies to those people if I'm saying their last name incorrectly. Gerald and Donna Merce, Frank Payton Dunn, Patsy Tatum, and Barrier Equipment Incorporated. That we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA scheduling efforts. That we refer the application to SOA for a contested case hearing on the following issues. 1, whether the proposed plant will be protective of the health of the requesters, their families, and full-time residents, including sensitive subgroups and physical property. 2, whether the proposed plant will negatively affect air quality. 3, whether the proposed plant will be protective of general welfare, including vegetation, livestock, and the environment. 4, whether the applicant has demonstrated that it will use best available control technology. 5, whether the proposed permit will be protective against nuisance conditions in accordance with 30 Texas Administrative Code, Chapters 101.4. 6, whether the emissions from the proposed plant will comply with the National Ambient Air Quality Standards. And 7, whether the modeling analysis performed for the application sufficiently account for cumulative impacts in accordance with applicable TCEQ statutes, rules, and guidance. And that we set the hearing duration at 180 days from the date of the preliminary decision to the issuance of the proposal for decision.
Commissioner Lindley, you said set the hearing duration at 180 days from the date of the preliminary decision to the issuance of the proposal decision. Did you mean hearing, preliminary hearing?
I mean from 180 days from the preliminary hearing.
And in this motion also, you said chapter 101.4, but should that be section?
Yes. On issue 5, yes. I believe that's what you're talking about.
Yes.
Thank
So
you.
I think with those friendly amendments, we can take a second without having to repeat the motion.
I was going to say, I think I followed that perfectly, Ms. Smith, though. I would second that clarified motion.
All right, colleagues, the motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
I vote aye.
I also vote aye. The motion carries. Ms. Smith, please call the next items.
Items 6 through 20 are our enforcement docket, and the executive director's staff is here to present the matters.
Good morning.
Good morning. Can you hear me?
Loud and clear. Good morning, Ms. Cordell.
Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 20. The total assessed administrative penalties are $393,568, with $49,166 deferred, $67,492 applied towards supplemental environmental projects, and $276,910 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No, thank you.
Ms. Smith, has anyone signed in to speak on these items?
On item 10, we had an individual signed in who indicated that they were available for questions but didn't wish to present otherwise.
Thank you. I noticed the registration. I want to thank Mr. Norton for being here on behalf of the City of Garland, and just to mention that these nuisance odor issues are difficult ones, and we appreciate the city giving these issues their full attention. So I want to thank you for being here today, sir. Let's hear next from OPIC.
Good morning. OPIC reviewed these items and we support issuance of the proposed orders.
Thank you for that. I agree. I've reviewed these items. I think we should approve them. Commissioner Lindley, what are your thoughts?
I agree.
Commissioner Janeka?
Likewise, I'm in agreement, ready to move forward today.
I'll invite a motion, please.
Apologies. I just lost my place. I would make a motion that we
How about if I move that we adopt items 6 through 20 as recommended today by the Executive Director?
I'll second that motion.
All right. The motion has been made and seconded. Commissioner Lindley, how do you
Aye.
vote? Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 21 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present the report.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Brian Sinclair of the Enforcement Division, and with me is Melissa Cordell of the Enforcement Division and Charmaine Backens of the Litigation Division. We're here to present the monthly enforcement report for fiscal year 2021 through February. There were 489 effective administrative orders issued, and of those, 69 contained supplemental environmental projects. These orders assessed a total of $5,330,394 in penalties, with a payable amount of $3,341,078. $1,065,751 are to be paid towards supplemental environmental projects. 6,733 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 812 enforcement action referrals have been received. There are 1,535 pending administrative orders with 230 cases that are on the backlog. 209 cases are pending at the Attorney General's office for representation in district court, and 7 judgments have been issued. 2,066 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2019, 2020, and 2021. We are available to answer any questions that you may have.
Thank you, Mr. Sinclair. I have none at this point. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
No questions. I appreciate the report.
Ms. Smith, has anyone signed in to speak?
No one is registered.
And Mr. McWhirter, what are your thoughts?
I appreciate the report. I don't have any questions.
I think we're all good. No action is necessary on this item. So, Ms. Smith, I'll ask you to please call the next item.
Item number 22 is the consideration of the agency post-incident response actions related to the February 2021 severe winter storm, including plans to evaluate factors that impacted public water system response and recovery. The Executive Director staff is here to present.
Thank you. Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Brittany Wortham-Sequel, Special Assistant for the Plan and Technical Review Section in the Water Supply Division. With me today is Carrie Michelle LaKyle, Deputy Director of the Water Supply Division. During the March 31st, 2021 agenda, the Winter Storm Uri After Action Review project proposal was presented. I'm here to provide the project team's monthly status update for the work completed to date and next steps for the project. The project team has developed a survey that will be made available to all public water systems at the end of April. The survey was created to collect additional information concerning the impacts of the winter storm, as well as information about what actions public water systems took that mitigated any impact from the storm. The survey asked questions generally related to resiliency, including system preparedness and response, system functionality during the storm, boil water notice issuance and recent processes, emergency power, the system's ability to plan, prepare, or respond effectively and efficiently, assistance opportunities relating to storm impacts, the adequacy of currently available guidance materials and training, the availability of water system resources like fuel and chemicals, the cause of the greatest impacts, as well as any successes that helped lessen the impact of the storm, and other information that will allow us to identify trends in the data regarding what types of systems may have been the most or least impacted. The work group has created a postcard that will be mailed to all public water systems that will include a link and a QR code, which will lead directly to the survey when viewed through a smartphone's camera. The postcard will also provide the link to our new After Action Review webpage, which will have updated information and announcements as we progress through the project. The website will also include the link to the survey, and stakeholders will be able to register for the upcoming roundtable discussions. The After Action Review website will go live once the postcards are mailed with the survey link at the end of the week. In addition, a dedicated email address has been created so that stakeholders and the public can submit questions or comments about the project, the survey, or future stakeholder discussions. The email address is winterstorm_PWS@tceq.texas.gov. The project team created a brochure that will be used to advertise the After Action Review project and to solicit stakeholder participation. We will distribute the brochure to the appropriate legislative leadership. The After Action Review project was advertised at the April 13th, 2021 Drinking Water Advisory Work Group meeting to begin recruiting potential stakeholders to participate in the upcoming roundtable discussions. After the survey is mailed at the end of April, the team will begin to schedule stakeholder discussions, which we anticipate beginning in July. Moving forward, the project team will begin to compile the data as survey results are received, design stakeholders' discussions to continue to identify key issues that led to the cascading failures across critical infrastructure and those that affected restoration of services, conduct a literature review for best practices, talk with industry experts, and begin planning presentations, training, emergency preparedness and planning exercises, case studies, and lessons learned from the storm at the annual Public Drinking Water Conference in August 2021. That concludes my first update of the Winter Storm After Action Review project. We welcome any feedback that you may have, and I'm available to answer any questions.
Thank you, Ms. Tico. I have none. I appreciate all the progress that you've made, and very eager to see the results of this. And I don't have anything else at this moment. Commissioner Lindley, any questions?
Will you just say again when y'all are planning on mailing the postcard out? And just to clarify, I'm calling them the roundtables. I don't know if that's what you called them, but did you say those are starting in July? Did I write those down correctly?
We anticipate the postcard to be mailed out this week, by the end of the week, and correct, July is when we anticipate the discussions to start.
That's the only questions I had. I appreciate the update, and I know a lot of work has gone into it so far, so appreciate that too.
Thank you, Commissioner Lindley. Commissioner Janeka, any questions?
No questions at this time. I really appreciate the update, and I look forward to looking at the survey when you send it out. I'm pleased to see that we're including new tools like QR codes and links and things like that as we try to make it easier to get the information out to our public entities. Thank you.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak on this item?
We don't have anyone signed in on this one.
All right, and Mr. McWhorter, what are your thoughts?
I don't have any questions. I know a lot of hard work by staff is going into this, and I appreciate it. Thanks for your report.
Thank you, Mr. McWhorter. And Ms. Tico, thank you again to you and your whole team for all the effort on this. It's an important project, and we appear to be doing it well and on track. So keep it up, and we look forward to the next report. There's no action necessary on this item, which will take us to executive session. I understand we're not meeting in executive session today. I'll let Ms. Smith read the caption and wrap us up here.
That's correct. Items 23 through 26 are for closed session, and the commission will not meet in closed session today.
With that, the time is 10:09 a.m., and we are adjourned.